Thank you very much, Member Allen. All right. Apologies for absence. Member Paulwell. Apologies for him. He has indicated to me that he will be available for the next meeting. And also for Member Dana Dixon, a new member of the committee, who is at a function that I was at that I had to leave to come to be here for 10 o'clock, and she will be joining us late. Do you have any others, Ms. Beckford, any other apologies?
Minister Albin Hill.
Minister Albin Hill. Okay.
Minister, I believe last week, Member Jackson had indicated that he would not be able to be at this meeting.
Yes, that's correct. That's correct. That's correct. Absolutely, yes. So apologies for him. All right, so members, last week, Ms. Campbell concluded her presentation on the references to the single buyer in the Electricity Act. The committee then continued the review of the matrix and completed sections 47 to 51. Regarding the JPS suggestion, read section 47.6, that the definition of a significant power outage should be in line with the definition of a major system failure. The ministry is to provide a response at this meeting. Ms. Campbell was also asked to provide a response to Senator Allen's question as to whether representatives from the JIE and the Professional Engineers Board are part of the Committee of Examiners who determine the requirements for the registration of electricians. The ministry is also to revisit the provisions relating to the rural electrification to provide clarity in relation to those circumstances where the main service provider could not or did not wish to provide electricity for certain rural areas and another entity or individual opted to provide such services. For example, what would constitute encroachment? Ministry was also asked to consider the possibility of providing incentives for those entities that opt to provide that service. So this meeting is quite quick in terms of the date of the last meeting and this one. So I guess Ms. Campbell will advise us when she starts whether or not she's ready to respond or she needs more time. And if so, obviously we will take that up at the next meeting. So we did end at the sections 51. So I think at this point, we'll ask Ms. Campbell and the team to continue the matrix, and hopefully we can get far in the aim to conclude the review of the Electricity Act. There are some dates proposed for the next meetings that I will take at the end. But I see that we have 2 dates that have been proposed, which are in October. So we are moving closer to that timeline that we're trying to achieve, which is the conclusion. So let me ask Ms. Campbell and the ministry team if they want to take over right now so we can jump right into it. And of course, you can deal with these outstanding matters and give us an update on that at the beginning. So Ms. Campbell, over to you. Thanks.
Good morning, Minister. Thank you. Good morning, everyone. I'll begin by way of updates on some of the matters expressed. In relation to Senator Allen's inquiry regarding membership of the JIE and the board of the Committee of Examiners, I'm advised there is a representative from the JIE on the Committee of Examiners. In relation to the rural electrification, we are requesting an allowance to make that presentation at the next meeting. And Minister, could you clarify, did you ask for an indication as to the timelines for conclusion of the meeting?
You mean for today's meeting or for today's meeting?
No, generally,
No,
did you?
no,
Okay.
we had asked you before when based on what was left to be done, when
Okay.
you we could aim at concluding, and it was kind of fluid. So I don't know, maybe at the end of today's proceedings, you can give us an idea as to what is your thoughts in terms of the conclusion of the matrix.
Okay, Minister. I'm just checking to see if I had missed anything else. I gave an update on the rural electrification provision and the question regarding the committee of examiners. If not, then
Ms. Campbell, there was the issue of the JPS's recommendation section 47.6 about the definition of a significant power outage being in line with the definition of a major system failure. You had asked for some time to come back today with a response.
okay.
That's in relation to the section 47.6. The definition of a significant power outage should be in line with the definition of a major system failure. Ministry is to provide a response at this meeting. That's what you're referring to, Ms. Beckford?
Yes, Chairman. Ms. Campbell had indicated that there was a difference between the two and that the ministry was still reviewing the issue, and she had asked for some time to respond at this meeting. So she can decide if she needs more time.
Okay. When we considered further, we noted that the electricity sector book of codes separate what obtains when there is a significant power outage versus a major system failure. And we thought that we needed to discuss this with the OUR. So we're asking for a little more time until the next meeting so that we can clarify something for the OUR in that. Okay. So we begin today at section 53, which contains the general penalty provision. The OUR proposed that the provision should be reviewed and revised as it appears that the information is missing in relation to penalty applicable to a body corporate. Now, when we looked at the provision, the provision allowed for the person directing the body corporate to be held responsible. And it wasn't clear whether it was the body corporate or the person who is directing the affairs of the body corporate that should be held responsible. When we looked at the Interpretation Act, Section 49, there is allowance for the body corporate to be held responsible for any offense in law and subject to the direction of the Office of the Director of Public Prosecutions, rather. So there is no there is provision in law for a body corporate to be held responsible. And usually if there is sentencing, etc., that would be provided under the penalty, then whoever was directing the affairs would have to serve the term on behalf of the body corporate. So in line with what the OUR has mentioned, our proposal is for the body corporate to be specifically stated, and because there's no issue in law with that. We also have a recommendation for the offenses per the different sections throughout the Act to be listed in a schedule to the Act, so that the minister may be able to exercise his authority whenever the time is opportune for the schedule to be amended and for the penalties to be updated. I will now go to another matrix where we considered the different sentencing options that are available. Okay, so we picked out the sections to which the general penalty provision applies. I'm sorry, that's the wrong version. Okay, this is it. I crave their indulgence. Okay. All right, so it should be on the screen now. So in relation to Section 7, subsection 3, there is an offense created where a licensee fails to comply with a request from the minister for information for the purposes of system planning. Under the general penalty provision, which is disclosed here, any person who commits an offense against this act for which no penalty is specifically provided is liable on summary conviction in a resident magistrate court to a fine not exceeding $5 million in the case of an individual offender. In the case of a body corporate, an individual responsible for directing the affairs of the body corporate, to imprisonment for a term not exceeding 2 years, or to both such fine and imprisonment. Now, our recommendation is to separate or to give different weight to an offense that would be suitable to be applied to a body corporate as opposed to an individual. You will note from the existing provision that there is a $5 million fine, and in lieu of the fine, or where the court determines that both should apply, there is a term not exceeding 2 years imprisonment. Now, we looked at the provision again, and we thought that the existing provision could remain in respect of a body corporate, but in respect of an individual, a fine up to 2 million or 1 year imprisonment or both would be appropriate. We also considered that this penalty could be added to the offenses to which a fixed penalty applies, so that liability to conviction may be discharged by the payment of the fixed penalty.
And you're proposing the fixed penalty to be 2 million for the individual?
Up to 2 million for the individual.
Up to
Yes.
2 million, coming from 5.
Coming from 5.
Might I ask, Minister? So it says here, any person who commits an offense against this act for which no penalty is specifically provided. What offense is there that would have no penalty? Like, what falls into this category?
Yes, so if I may respond. So if you look at this section 7, subsection 3 here, this is the existing provision. It says a licensee shall comply with a request made by the minister for information for the purposes of executing his planning responsibilities under this section, and failure to comply with a request under this section without reasonable cause shall be an offense. So if you notice, the offense is created, but the specific penalty was not stated. So this general provision would apply to provisions of that kind. In section 8, subsection 4, now I've extracted here the provisions following, but this provision essentially requires a person who engages in or wishes to engage in generation, transmission, distribution, dispatch, and supply of electricity, or where the person erect, maintain, or have an electric line or other works over, along, across, or under any street or public road for purposes of supply of electricity to have a license. Subsection 4 says, any person who contravenes subsection 1, which I read above, commits an offense. So generally, the fixed penalty provision up here would apply. We thought along the lines of the previous recommendation that the penalties for individual and body corporates should be separated, and we present for the committee's decision the fine of up to $5 million for a body corporate, or imprisonment not exceeding 2 years, or both fine and imprisonment. And if there's an individual offender who is convicted, a fine of up to 2 million or 1 year imprisonment, or both.
So this is in essence, Ms. Campbell, the same fine as the not providing information to the minister when requested?
Yes.
And this one is for a person who's basically transmitting, generating, and dispatching electricity.
Yes.
Well, my view is that they seem to carry different weights. You know, the nature of the offense seems to be significantly greater. I don't know That's just my view, Minister.
So then your suggestion further would be for the penalties to vary differently from what is proposed here?
If I understand it, as
Yes.
you that the first one that we discussed speaks to a lack of response for information to the minister in his or her planning purposes, and this one is basically you're transmitting electricity, you're generating and distributing. You could be operating a whole new JPS, you know, for want of a better term. I'm not seeing how both offenses, why they carry the same weight in terms of the fines.
Okay.
Maybe there should be some consideration in reducing the previous one. And I mean, this obviously requires some discussion. And because I believe this second one has a greater impact. That's my view.
Okay. When we looked at it, we thought that as a matter of public interest, from that perspective, they would carry the same weight. But we did consider your concern, and we concluded that on a matter of public interest, they carry the same weight because system planning functions is very critical, notwithstanding it's information that is requested. But we will yield to the committee or any other views.
So what is your position, member? What are you suggesting?
I am suggesting that the offense of the lack of provision of information should carry a lesser fine, as opposed to the what that fine should be. We can discuss, but I do believe that they differ. Although I understand what Ms. Campbell is saying is that if you do not get sufficient information, it can impact the planning and subsequent provision of electricity. But I as it stands now and on the face of it, my view is that the fines should differ. And therefore the first one should have a lower fine, not the same 5 or 2 million or 2 years and 1 year.
Member Campbell, Roland Campbell, as our legal member, any comment on it?
They're not at this time. I'm reserving my comments to look at the issue.
All right, so you want us to put a question sign on that until we give you an opportunity to look at it and we come back to it?
Grateful, Chairman, and that might be at the end of the meeting.
Excellent. All right, so that one, we flag that one, please, Ms. Beckford, Ms. Campbell.
Chair acknowledged. In relation to section 28, any person who unlawfully and maliciously cuts or damages any electric line or work with intent to cut off any supply of electricity commits an offense. We considered that this is a very serious act, and as such, the existing penalty of 5 million would apply to our body corporate, and 2 million to an individual. The consideration is that the supply may be cut off to critical areas, hospitals, which require a steady supply, and industries for manufacturing or other purposes, and the extent of the act may have far-reaching consequences.
Good morning, Chairman. My name is Peter Johnson. Are you hearing me?
Yes, sir, we're hearing you.
Yes, good morning. I'm new to your committee meeting, but as I'm looking at this particular clause,
Where are you from, sir?
Oh, sorry, I forgot to identify. I'm from the OUR, Office of Utilities
Okay.
Regulations. Right, and I'm just looking at the verbiage as it is there. And
Excuse me, Mr. Johnson.
Hello?
Yes, your camera is to be on while you're speaking.
Oh, camera, where is that now? Let's see if I can get that on for you. That should be it. Are you seeing me?
Yes, we are.
I've lost your screen for some reason. All right, let me bring this back up. Okay, right. Yes, so the verbiage as it is there seems very wide, as in any electric line or work with intent to cut off any supply of electricity. It sounds very wide. I know the context is of the public utility, but this does seem rather wide. I'm not sure if there should be any qualifiers to this.
Minister, I tend to, I'm curious, the question that has just been raised by Mr. Johnson, I myself would be curious whether there might be an opportunity to qualify different types of disturbance or disruption to service. I'm not sure who would be able to provide that, but that might be useful information to determine the fines, if there's a graded fine or graduating fine.
If I can just follow up on that, Chairman. And that's an excellent point, Ms. Allen, because indeed the electricity system does have different categories of lines and systems, some of which have much greater impact than others, in particular transmission systems or your substations, and lesser would be your distribution lines. So indeed, you may want to have some categorization there. And as I said, just to make sure that any does not include something on a private system.
Ms. Campbell, you have any response to that?
Minister, I would not readily be able to say which lines. That's in a technical realm, but I would take advice.
So we have a input from OUR and from Member Allen. Both of them seem to be concurring. Am I correct on that?
It would seem so, Minister. We're both desirous of the same information.
Yeah. All right. So you want us to flag that, Ms. Campbell, and give you opportunity to look at it?
Sure, Minister.
Okay, great.
I think you have a question, Minister, from the AG's office.
Go ahead.
Minister, I'm not sure if we lost the Attorney General's department.
It seems so. Let's give her a chance. Keith, my problem is I see the AG says she's typing on the chat. So I think Ms. Campbell, we need to look on the chat. I think she's having an audio problem. I'm not sure what's happening with audio. I apologize. Please proceed. I will type my comment here.
Good morning, Chair.
Uh-huh. Go ahead.
Can you hear me? I'm going to.
Sure, I'm hearing you. I'm hearing you loud and clear. Go ahead, Ms. Eaton.
Hello, good morning. Just to follow up a bit on the discussion that's taking place, I just thought it would be useful for the members of the committee, indeed for us to remind ourselves that when you're looking at a criminal offense, we're looking at both the mental and the element, as well as the acts that constitute the offense. And so when looking at the particular offense, which is any person who unlawfully and maliciously cuts or damages any electric line or work with intent to cut off any supply of electricity. So I thought it would be useful for us to remind ourselves that, one, the perpetrator of the act intends to cut off the supply of electricity, and that the act is not done inadvertently or accidentally, but unlawfully and maliciously. So in looking at the offenses, just, we can bear in mind the elements of the offense. I'm not quite sure if the reference to the offense being wide, if what was intended in terms of Mr. Johnson's intervention, whether or not it was, is it that the nature of the infrastructure that is damaged? I wasn't clear on that point, but I think it is useful to note that the perpetrator of the offense does so with the intent to cut off the supply of electricity. Thank you.
No, tell me, Seaton, very good point made there. Ms. Campbell, you note that?
So Chairman, if I may,
Go ahead.
if I'm not hearing Peter Johnson respond, this is Shani Riley from my camera. Shani Riley from the OUR. So for example, if someone cuts off a distribution line, it may have a smaller impact in terms of the number of customers as opposed to a transmission line. So that would give justification for a tiered set of fines, for example.
Oh, did Ms. Riley? Member Allen?
Yes.
Member Campbell?
Yes, Minister.
Anything on that?
I would look forward to a recommendation for the tiered fines. Yes.
Member Campbell?
I think Member Campbell's having.
Concur with that, sir. I'm starting now, although I can't see a camera on. Jim is not recognizing.
Okay. All right, I think I haven't seen anything come on the chat. So I'm hoping that they will sort out the audio. Ms. Campbell, you want to proceed?
Sure, Chair. Proceed. I was trying to find my. For section 30, any person who obstructs an agent appointed under section 29 in the execution of his duties under that section commits an offense. We thought that the existing fine of up to, and bear in mind the maximum is 3 million. So the court, on this, based on the circumstances, may determine that fine, the maximum, might not be appropriate to apply. So we thought a body corporate should bear a fine of up to $3 million or imprisonment for 2 years, and an individual, that should be 1 million. It was 1 million that we were proposing, or 6 months. That was an error for section 30. Any comments or concerns?
Silence is consent, Ms. Campbell, go ahead.
Section 45, deals with the role of the system operator, and if I may remind the committee, the system operator handles the dispatch activities, and based on the current provisions in the law, it should be a ring-fence department within the single buyer. So if the system operator contravenes any of the provisions in the Act in relation to the functions the system operator carries out, then we thought to keep the existing fine. So the system operator is the licensee holding the dispatch license and is a ring-fence department within the single buyer.
Hello, Chair.
Go ahead.
My apologies for, I don't have the raise hand feature, unfortunately. I just wanted to bring to the members' attention that AGC's message has come through.
All right, let me read that message now. Mhm. I'm having a difficulty. Can somebody read it out for me, please? Ms.
In
Campbell.
response to Senator Allen's query earlier about the weighting of penalties, I noted that the proposal was in relation to a general penalty clause for offenses where no penalty was specified and not just the offense in section 7. So I just wanted the committee to bear that in mind when deliberating on the penalties.
Noted. Any comments on that? All right. AGC's comments noted. Right, Ms. Campbell.
Section 48, subsection 4. In performing its functions, the government electrical regulator or its agent shall have the right of entry to any premises or property, and any person who so obstructs the government electrical regulator or its agent commits an offense. Our counter recommendation to the general penalty that applied in respect of a body corporate, our recommendation is for a fine up to 3 million or 2 years, and for an individual, fine up to 2 million or 1 year in prison. There are no questions. I note that we have to come back on section 28. Proposal for section 28. And I will stop sharing this particular document. We move on to section 54, which contains a provision for fixed penalty schedule. The OUR recommendation concern is that for section 54, the fixed penalty schedule only covers 3 offenses. It is proposed that this be expanded to include additional offenses so as to incentivize compliance. It is recommended that the offenses in the Act that are best suited for treatment under the fixed penalty scheme should be identified and added to the first schedule with appropriate penalties. In the initial presentation, we recommended to the fixed penalty schedule, section 7. So if it is that the liability for conviction would not apply if the fixed penalty is paid, and that is a section that covers the offense where the minister's request for information for system planning purposes is not complied with. So that is our response to OUR. We have further amendments recommended, and we obtained guidance from the Companies Amendment Act 2023. The ministry proposes for consideration an amendment to section 54 for subsection 1, it is our recommendation that the word regulations be made to apply not only to offenses created in the Act, but also offenses in regulations made under the Act. So if there are, so that the fixed penalty regime should also apply to regulations made under the Act where the offense in the regulations, there's a fixed penalty that is applied. Section 54, subsection 2, we recommend inserting in the place of the word that offense appearing in the penultimate line, the phrase, the offense concerned, to make applicable to a broader spectrum of offenses. For section 54, subsections 4 and 6, the references to local authority, we recommend that be deleted because based on the scan of the Act, there is no provision which empowers the local authority to perform any function in relation to a breach of any provision under the Act that is subject to a fixed penalty. So in relation to subsections 4 and 6, we are recommending that the references to local authority be deleted. And further, in relation to subsection 6 rather, of section 54, we are requesting that that clause be amended to make provision for another payment option, that is by electronic means, in accordance with the electronic transaction. The electronic receipt of payment is to be accepted as sufficient evidence of payment. So in the existing provisions, payment is to be made to the collector of taxes. We also thought that in the present reality where payments are done online, that payment may also be facilitated online, not necessarily physically entering the space. In subsection 9, it is our recommendation that
I'm sorry, Ms. Campbell, you're a little muffled. I'm not sure if you can make some adjustments. Can you try again?
In relation to section 54, subsection 9, am I any better?
Yes, thank you.
Okay. We are recommending that subclause D be added to include that this provision.
Sorry, Member Campbell asked you to just take over for 10 minutes for me. I just have a call coming in. Thanks.
Yes, Minister. Ms. Campbell.
Okay. So the current provision says that the minister may, by order subject to affirmative resolution, make provision as to any matter incidental to the operations of this fixed penalty section, and in particular, which may prescribe that the fixed penalty offences, the section apply to fixed penalties under the Act and under regulation. So among the other things that the minister may by order prescribe is the form of the notice to be given to someone who has committed an offense and the collector of taxes to whom a fixed penalty is payable. The The order may also apply to the nature of the information to be furnished to the collector of taxes along with payment, the arrangement for the collector of taxes to furnish the office, which is the OUR, information with regard to the payment under a notice under this section. And we're also seeking that the minister may make an order in relation to fixed penalties in relation to offences under the Act and under any regulations under the Act.
Member Allen, we're okay with that?
Yes, Chairman, I almost said yes, Minister.
Go ahead, Ms. Campbell.
Section 55. And this is the section dealing with the power of the minister to make regulation. The Office of Utilities Regulation, in their recommendation for this section, says that with regard to the power of the office to make rules, it is suggested that language similar to that used in the telecommunications be considered. They offered a proposed for the provision, which reads, the office may, after consultation or subject to the consent of the minister, make rules published in the Gazette prescribing any matter required by this to be prescribed by such rules, or any matter that it considers necessary or desirable for the effective performance of its functions under this Act. Now, in considering this proposal recommendation, the OUR, we looked at the provisions that they highlighted, which exist in the Telecommunications Act. Section 4, subsection 5 of the Telecommunications Act specifically authorizes the office to make rules subject to affirmative resolution prescribing the system of regulatory accounts to be kept by a dominant carrier or service provider in relation to specified services. In relation to section 50, which is another section which authorizes the OUR to make rules, the office may make rules subject to affirmative resolution prohibiting or regulating conduct that is likely to result or results in the avoidance or distortion of the process, international settlements, etc. Our challenge here is that the OUR is asking us to allow them to make rules with a modification to this section. But this section specifically contains the regulation making powers of the minister. And we are not clear from the OUR's proposal what issues would inform this proposal, what specific matters should. I know that the language they have given us is wide, and in one sense, we can glean from the fact that it relates to their functions under the Act. And we do also note that unlike the telecommunications regime, the ministry issues the licenses and considers the application for electricity. But in relation to the Telecommunications Act, the OUR receives the applications and determines whether or not the license should be granted and advises the minister in respect of same. So we were unclear in relation to the both regimes, what would obtain, and we were unclear as to the specific matters that the OUR deems that their a rulemaking power should be carved out to facilitate their functions under that.
Why does the OUR need that power though? If the minister has the power to make the regulations, wouldn't the OUR not simply provide its position to the minister for the minister to act? What's the benefit of the OUR having this power? Why is it essential for the OUR to have this power? Ms. Riley, you're muted.
Yes, Chairman. So we have found in terms of our exercise of oversight over the varying sectors, there is definitely an advantage to having a rulemaking power because that enables us to, through subsidiary legislation, publicize what are often administrative or technical rules and procedures that are applicable to the sectors. Certainly in the case of the Telecommunications Act, it's much more specific in terms of some of the particular areas for which we are required to give effect by way of rulemaking, and then a general power to make rules if we deem it appropriate in the circumstances. And so it is that similar power that we would wish to have with regard to our oversight of the electricity sector. So we may find, for example, in exercise of our tariffing activities, that it may be useful and beneficial to the sector for us to set out our procedures and the matters that influence our decision-making in the form of a rule. And to the extent that in our regulation, there are any technical requirements that would be of benefit to the sector to be publicized by way of rulemaking, we would wish to have that power. In addition to that, that power not be subject to the affirmative resolution of Parliament, because those are usually of a technical nature, so that there be an obligation for us to consult with the minister in that regard. There is a difference or a distinction in the roles of the minister and the OUR with respect to its oversight of the sector too. So the minister may, if he chooses, to consult with us in the event that the minister wishes to make rules with respect to his functions. But then what we are proposing is that the OUR have a separate rulemaking power with respect to its own functions. And for full transparency, etc., there be an obligation for us to consult with the minister before we bring that into effect. I don't know if that gives some clarity.
Well, I think I understand you, but let me see if this is working. I think I understand you, but my concern is the rulemaking power that doesn't have the benefit of the people's representatives is a little concerning to me. And I hear you on the technical, but at the end of the day, a breach of a rule leads to a sanction.
That is correct. In terms of our process, which is perhaps by convention with respect to our oversight of sectors other than telecoms, and it is legislative with respect to our oversight of telecoms, we are in fact obliged to consult with persons who are affected by our decisions prior to bringing them into force. And so we have adapted that approach that we are mandated to apply in telecoms to all of our activities with respect to the other sectors. And so, in fact, before we do implement a rule, we do actually consult with stakeholders who are impacted. So depending on the nature of the rule, if it is only IPPs or electricity or GPS, we will consult with them. If it is something that affects a wider sector, we will have a broader consultation, with consumers as well as all others affected. And then that will inform our recommended rules. And then we will have a consultation with the the minister, and where, as a result of that consultation, the rules that we are proposing are endorsed, then they will be brought into force. So that is in fact the approach that we use in telecoms, that we would likely use on the electricity. And we actually don't have any objection to there being an express requirement that there be this application of natural justice prior to us implementing any decisions.
I hear you. I hear you, Ms. Riley. Member Allen, I'm not persuaded, but Member Allen, your thoughts?
Honestly, I mean, certainly we can always get more information, and we can go back and forth on this. And I usually trust your judgment when it comes on to these types of considerations, Senator Golden Campbell. Is there any other perspective? I mean, I wouldn't want us to hold up the entire meeting on this matter. Maybe it is something to review even further. And maybe when minister settles, or we can look back at it as something to further contemplate.
Good morning.
Oh, thank you. Go ahead, Ms. Eaton.
Good morning. I just wanted to interject in that certainly from a drafting perspective, there is nothing particularly unusual for a single act of parliament to actually have different enabling provisions with respect to subsidiary legislation. So for example, typically you have the general regulation making power, which is conferred on the minister, but you do have legislation where, as Ms. Riley indicated, you have rulemaking power or another form of subsidiary legislation that can be made in respect of very specific issues. I also wanted to indicate that it is not unusual for the exercise of delegated lawmaking function to actually be subject to terms. So for example, we have legislation where the exercise of the rulemaking power is subject to the approval of the minister or other requirements. And on the matter of affirmative resolution, most regulation making power is actually not typically subject to affirmative resolution. And that is usually reserved for matters that are of particular national significance, where Parliament wishes to retain oversight of the subsidiary legislation. So there are actually a number of different approaches that can be taken. It just depends on the policy. Thank you.
Thank you. Thank you, Ms. Eaton. Would the AG Chambers wish to comment on this one? Okay, thank you. Member Allen, I think perhaps okay, AG Chambers is saying they're agreeing with the Parliamentary Council. Is the suggestion, or rather the proposal by the OUR, is the draft of it, or the language of it the best language, or is it that Parliamentary Council, are you saying that we could rework this to introduce the different enabling mechanisms that you spoke about?
Yes, as I had as indicated, that the terms of the regulation making power are a matter of policy. So for example, you'll see legislation where the statutory body is conferred with rulemaking power, and it is something that is delegated to them and there's no qualification to it. In other formulations, you'll see where it's subject to the approval of the minister, or they may be required to consult with a particular body. Again, it just depends on the policy.
Is the ministry any more persuaded then that a policy could be crafted to ground the proposal by the OUR? I'm sorry, I'm seeing Minister Fitzmaurice's hand.
Hi, I think you asked the question that I was asking. Thank you. And I was listening to the OUR's explanation for the need to make this adjustment. I'm not fully convinced that it is a necessary amendment that has to be done, but I would say that this is definitely a policy decision. We have to, the ministry will have to tell us whether or not in their thinking this is the way they want to do it, whether or not they want the minister to have that power, or whether or not they're comfortable in this instant to delegate some of that rulemaking authority to the OUR. I think it really rests with the ministry, and I'll support whatever their position is.
Thank you. Ms. Campbell?
Thank you. Well, the OUR was clear in terms of the explanation given, and this is something I have to confer with the team on, and then we would then thereafter advise the committee further.
Okay, so we look forward to that. Okay, we can move on.
Further within section 55, at subsection subparagraph rather H, the minister excuse me, may prescribe provisions in relation to the implementation of intelligent network technology after consultation with the office and the single buyer. We propose that we replace intelligent network technology with smart meters and other intelligent network technology. Subparagraph I.
Ms. Campbell, you're a little muffled.
Am I clear? Because I'm having
I think there's generally a problem with your microphone. It's just not very clear at all. You cannot be at the Ministry of Technology.
We're no longer the Ministry of Technology.
Yeah, wrong ministry.
Okay, I'm foregoing the headset. Am I clear?
I think so. Go ahead again.
Sure. For subparagraph I, we were proposing that this provision, we're going to request that we come back to it because we have not yet settled the matter concerning the system operator, section 45 rather. So I will flag this. This will depend on what the outcome in terms of what needs to happen to that section. For F, we propose just a slight amendment. The subparagraph empowers the minister to make regulations for fees that may be charged in relation to applications for electricity licenses. And we recommend a slight amendment to say application and processing fees that may be charged in relation to electricity license. So paragraph G, the current provision requires regulations concerning requirements relating to energy efficiency, including measures to reduce demand for electricity. We are proposing to add, after including measures to reduce demand for electricity, to insert such as demand side management. And DSM is the name for a number of methods used to control demand. So I think that's just for clarity. We're also recommending that the minister be empowered to make regulations to provide for other arrangements for the generation and supply of electricity consistent with section 9(1)(d). I will pause here to indicate in section 9(1)(b) of the Electricity Act, the minister may issue a license for net billing, wheeling, or other arrangements. Now, the thinking behind this proposal is that there may be other arrangements along the lines of net billing, wheeling that we may contemplate in the future. And so we wish to have the legal framework fully settled where the minister is so empowered to make regulations concerning arrangements which are not identifiable at this stage, but which may come up in the future, and therefore would not necessarily necessitate an amendment to the Act itself.
Okay. Any comments on that? As Minister said, silence is consent. Ms. Campbell, go ahead.
Sure. We move to section 56. And section 56 empowers the minister by order to amend, subject to affirmative resolution, any monetary penalty specified in the Act, and two, to amend any schedule to this Act. The OUR, well, their proposal is similar to their proposal above, and our position was the same. So we would come back to this when we deliver our position on the one above. This is in relation to their proposal for have thought to make rules. They had another recommendation that the minister's power should amend any schedule of the Act, with the exception of monetary penalties, and I would add also custodial sentences, and that would be subject to should be subject to a negative resolution. Having considered the great issue with that, because there are sections, there are schedules. For example, the right of first refusal or the tribunal, which we think they could be amended if the need arises without having to require affirmative resolution. So we agree to the amendment of any schedule, excepting those which may have to do with monetary penalties and custodial sentences.
Okay, noted. Comments? You have agreement, Ms. Campbell.
Section 58, and this section contains a provision for unlawful obstruction or use of electricity. The OUR, in their comments, the Joint Select Committee says that in section 58, the offense of unlawful obstruction and use of electricity should be applied to electricity transmitted, distributed, and not on electricity supply. It should include a reference to all electricity licenses. It is proposed to consider replacing the reference to electricity supplied by a single buyer with electricity transmitted, distributed, or supplied by any electricity licensee. This particular recommendation also is related to the whole discussion concerning the single buyer. Based on how the reference to the single buyer appears, I know that initially we did not support the provision, but we wanted to await the decision regarding the single buyer. And our initial thought is that the single buyer is the only entity which supplies electricity, and in that respect, we did not consider that it was highly significant that other licensees be included here, because there is no functions or activities that they perform in that respect. Now, we notice that it says a single buyer, which could mean any other supplier. So notwithstanding that, we consider that there is a possibility that it may be extended to other licensees who would have any function of supplying electricity to premises. So we have this, I sound a little confused.
I'm waiting to comment eagerly.
Okay, so our initial thought, as I indicated, was that the single buyer is responsible for supplying electricity to households, to premises, in the current context. No, we do not have a challenge if it is that there are other licensees performing that function, and we note in the act that by virtue of the definition of electricity license, a license may be issued to one or more persons regarding the chief activities under the act: distribution, transmission, dispatch, supply. So in that sense, then we would not have an objection to the OUR's comment extending it to licensees. As I indicated, this was our original position, having interpreted what the provision required and in relation to what obtains now.
Madam Chair, if I may, I believe the position by the OUR is one that I would support. Never mind that we currently only have a single buyer, but by your own admission, Ms. Campbell, there could be, and if we're redrafting or we're updating this law, this act, this Electricity Act, to take us beyond where we are now, we have to write it in such a way that it does address the current issues, but at the same time, it is going to be capable of governing what is to come. We wouldn't want to be going back and forth to make these types of changes from single buyer to licensee when we are going in the direction of the likelihood of having more than one licensee. So I would support the OUR as the regulator in suggesting that we make this amendment, and I find it, I would have expected that the ministry would share this view as the OUR has shared. So I'm in agreement with the OUR on this and would not want us to restrict ourselves by stating single buyer at this time.
To the chair, Peter Johnson here, I'd like to add a comment to that.
Go ahead, Mr. Tom.
Okay, there is a technical exposure for all IPPs between their generation plant and when it intersects with the grid. And changing it to licensee would therefore cover the entire system as opposed to just limiting it to after it gets to the grid system, since we want to protect the end user from having to pay for any losses, especially these kinds of losses. And that is also something to bear in mind, that there is an exposure, a physical and technical exposure from the IPP to the grid. That should be covered, that should be considered.
Okay, thank you. Comments on that? Member Allen is in support. Ms. Campbell, does that sway your position?
That explanation was critical, and I appreciate it, yes.
So my layperson explanation was insufficient. Okay, I'm happy for Mr. Johnson's intervention.
So we're accepting the OUR's position on this.
Sure.
I can support it too, Chair.
Okay, you have your response, Ms. Campbell. Go ahead.
The JPS has asked that the provision be expanded from just illegal connection and theft of electricity to include theft of JPS infrastructure, lines, equipment, material, plants, poles associated with the electricity grid and the supply of electricity, as well as receiving or being in possession of these stolen items. We have considered the JPS's proposal, and we think it's reasonable, having looked at other jurisdictions. Now, we note that at section 28, we had expanded that section to allow for the protection of electricity infrastructure damage, but that's in the sense of some willful act, as we discussed then. Here we also thought that in relation to the unlawful use, abstraction, or consumption of electricity, then the offense could be extended to include to include tampering with meter or meter installation for registering the quantity of electricity supplied. So the tampering would tie into unlawful abstraction and use because it wouldn't record the correct usage. And the theft of the infrastructure or equipment, material, plant for the supply of electricity, that could also be considered here. We have no great.
Yeah, okay, thank you. We're in agreement with that?
I see nothing to object with here.
Okay. You have your responses, Campbell.
Sure. The JPS has requested a special utility court, excuse me, a special utility court or dedicated court sessions, or alternately a fast track channel within the court system specifically dedicated to addressing the theft of service and or infrastructure related to utilities, and sufficiently resourced with prosecutors equipped to handle these types of offenses. We looked at other jurisdictions. We saw in India, for example, the Federal Electricity Act has provisions for a special utility court because it was considered that it was electricity theft was a grave issue there. And there are other countries that also, well, they use other means of addressing the issues other than the law or having a special court. In consideration of the fact that we do not have any data suggesting that the Section 58 is not useful in terms of stymieing the unlawful abstraction. And we also looked at the fact that the ministry is part of a stakeholder group that is considering all the data and the general issue of electricity theft, and to come up with a position and a way forward. We do not think at this time we have the information that would rise the level of advocating for a special court. And then there are other government entities that we would have to consult with in order to make this decision. And as such, we cannot accept or agree to the proposal that the JPS has made in relation to that. We believe the fine of unlawful abstraction is sufficient. So if it is that the incidents are brought to court, we believe that they would be addressed there. We have no information otherwise that there is any deficiency in that, and as such, we cannot accept the proposal given now as is.
Fully agree.
Okay.
The OUR, so the current provision has a requirement for the review of the legislation no longer than 5 years after the appointed day. The OUR is suggesting that it is a rolling requirement. We do not have an issue with that. In order to keep the law updated.
Ms. Campbell, you're muffled again, you know.
We're going to ask the Ministry of Technology to aid with the technical support.
Just repeat that for me, please.
Sure. So the OUR has requested that the periodic review of the Electricity Act within 5 years. Right. So we have no objection to that, and they've rightly pointed out the license to an end. The main license will come to an end in 2027, and that would be on. It would be less than 5 years, but it may offer us an opportunity to look back, depending on what the position is going forward.
So so what's the current review period?
It was 5 years from the appointed day. It wasn't a rolling period. It just said 5 years from the appointed day, and that was from 2015.
Okay. So the proposal is that for an ongoing, once this comes into effect, every 5 years at least, for there to be a review.
Yes.
Okay. I can agree with that.
Go ahead, Ms. Campbell.
Section 62 contains a transitional. Section 62 contains savings and transitional provisions. We're recommending that subclause 2 be deleted. The reason is that the provision has a qualifying period within 3 months after the appointed day. The appointed day was August 27, 2015, for the rectification of activities being carried out under any repealed legislation to be made compatible with this act. 3 months have expired, and as such, the provision is no longer relevant. We're proposing that it be removed.
We're proposing what, Mr. Last, that's what you said.
We're proposing that it be removed.
What was the reason for having this?
So the reason was to create a transition from the old regime to the new regime. So I believe there were licenses that which under the old regime, and to streamline it under this act.
Okay. Gotcha.
Activities.
Thank you. Okay, so.
And a period was given of 3 months after the appointed day. So the sun has set on that, I believe.
Okay, noted. Are you trying to say something?
Excuse me, Madam Chair?
Go ahead.
I just wanted to point out to the members that in relation to 62.2, typically transitional arrangements do become spent within the time frame. But what is interesting to me is that needs to be considered in conjunction with subsection 2 needs to be considered in conjunction with subsection 3. So there is this whole phenomenon of the subsistence of the existing license. So if the license period has not yet expired, so I'm just bringing it to the attention that notwithstanding the fact that you do have in subsection 2 a timeline in which an existing licensee was to address certain matters, you then have subsection 3, which says nothing in subsection 2 shall require an existing licensee to rectify or cease any activity which is authorized by the terms and conditions of its license, certification, or other authority referred to in that section. So I just wanted to bring that to the fore. Notwithstanding the fact that, yes, subsection 2, if no longer factually relevant, needs to be revisited in terms of an amendment. Thank you.
Thank you for that.
Okay.
Is it that we would have to amend the language in subsection 3 if we're removing 2?
Yes, from a drafting perspective, the 2, in considering the proposals, the recommendations for amendment, we would have to be mindful that to the extent that there are factual circumstances that you still have to make provision for transition, or that you have to
Go ahead. Or that you have to?
I think we lost her.
Lost her. And I now have a camera. Oh, here she's coming back.
Yes, notwithstanding the fact that there might be, in other words, in putting forward a proposal for amendment of the transitional provisions, one would have to bear in mind the factual circumstances that persist and would still have to be addressed.
Okay, so we would have to amend subsection 3. And that really would be a matter for you, Parliament.
Yes, it could be addressed with the drafting once the policy position is settled. So I just wanted to bring that to the attention of the members of the committee, that in considering subsection 2, one would also have to bear in mind subsection 3.
Ms. Campbell?
Before Ms. Campbell begins, in the meantime, Chairman, just for the record, I received a late apology for Member Hilton, who is with the Constitutional Reform Committee. And so I wasn't able to provide that beforehand, just for the record.
Okay, thank you. Ms. Beckford, I appreciate if you would note that.
So noted, Chairman.
Thank you.
I'm back. Thank you. Thank you, Member Campbell.
Go ahead, Minister.
Go ahead, Ms. Campbell.
Okay, so we will look back at that. For the fixed penalty at section 54, subsection 15, the PBCJ recommends in the first schedule that there should be a provision in the schedule to automatically adjust penalties with the rate of inflation as published by the DOJ or other entities prescribed by law to publish inflation rates. We have not seen in any legislation where this mechanism is. We consider that and we do accept the concern raised by the PBCJ on the need to update periodically the monetary penalties, chiefly to be in line with inflation and other realities, because we know that there were some penalties that were really outdated rather. But we have not seen this mechanism in any other legislation. We do apply the inflation rate when we update penalties, and the fact that the minister under the act has the authority to amend penalties subject to affirmative resolution And given that we have agreed to a 5-year cycle, that would be sufficient time, provided that the reviews are done within those time frames to update any outdated penalties and keep them current. So in concluding, the mechanism proposed by the PBCJ is not accepted.
Through you, Chairman, so and on the basis that every 5-year review will take care of that.
Yes.
Okay.
And the same consideration recommendation applies to the fixed penalty provisions generally, and the position is the same. We are proposing the repeal of the Electrical Survey Act of 1956. We note that the Cabinet decision dated February 9, 2015, had approved the repeal in this current act, but it is not listed, and we are putting it forward here. Move to the second schedule, and the OUR has given a recommendation in relation to paragraphs 1 and 2, and the second schedule has terms on which the system operator is to carry out its dispatch activities by way of the merit order dispatch. In paragraphs 1 and 2, the merit order system is referenced to the generation code, but this is more comprehensively addressed in the dispatch code. There's a lack of specificity in the use of the term licensee in these paragraphs. It is recommended that paragraph 1 should be modified to read as follows. The system operator shall establish and operate as part of the generation and dispatch code a merit order system. The current provision is that the licensee shall establish and operate as part of the generation code and merit order system for generation sets that are subject to central dispatch. So what the OUR is proposing is that the dispatch code be also expressly named here, because that code also applies to the functions of the system operator in carrying out its dispatch activities. We have no objection to that. References to licensee in the second paragraph and first paragraph should be replaced with system operators. System operator for consistency with the code. We have no objection either. In paragraph 3, last line, we propose to delete the word or next after the word transfer to enable the paragraph to read properly. In relation to paragraph 2, the OUR recommendation is that references to licensee should, so we've agreed to that. the system operator. We move to the third schedule, right of first refusal. The OUR recommends that at paragraph 1D, the replacement cost should not exceed the generation avoided cost, which will be updated every 2 years by the ministry with responsibility for energy and published. It is the view of the OUR that the above is not sufficiently definitive and needs clarification of the cost to be applied in the case where an avoided cost is not updated and published within 2 years. The recent NFE CHP plan is a case in point, resulting in the then GPE taking the decision to use the generating cost of the SJPC, which is another plan, as a proxy for the avoided cost. The current provision requires the ministry to update the avoided cost every 2 years. When it does the integrated resource plan. Now, in those scenarios, in that scenario that OUR highlighted, we interpret that an avoided cost was not available when that generation took place. So they are recommending, the OUR is recommending that there is a provision in the law which permits the GPE, in consultation with the OUR, to develop an avoided cost if one is not available at the time. Now, generally the 2-year cycle for the IRP should allow for an avoided cost to be available at all times. But we do understand that for whatever reason, an IRP might not be available. And should that event occur, then there is the backup for the GPE and the OUR to develop an avoided cost. And we have no objection just to provide a buffer. EMR Energy recommends that in section 20, subsection 3, that the right of first refusal provision of the Electricity Act of 2015 be deleted to assure that all future generation capacity, whether it is for thermal, renewable, storage, or other technologies, be procured by the GPE through open public competitive bidding programs. Okay, the failing in the removal. So we're going to say that the proposal to remove the right of first refusal is not accepted. What we would propose now is to have a sunset provision allowing for that provision to automatically become redundant at the end of the license to JPS, because the single buyer now currently has the right of first refusal given by law. They continue, failing the removal of the right of first refusal provision, it is proposed that the provisions are revised to apply to all other generators with facilities procured through competitive bidding processes. Require energy pricing offered to replacement projects to be no higher than those that will be paid to projects of the like type procured through competitive bidding processes. We did not agree to extending the right of first refusal to every IPP generating. The thinking of the ministry and the policy is to move towards more competitiveness to obtain greater pricing for customers or consumers regarding electricity. So that proposal is not accepted in that respect. The Jamaica Institution of Engineers, they have given a recommendation here, but it does not apply to the Electricity Act, but the Electrical Works regulations and in relation of the qualifications, and that would be dealt with there. The PSOJ has recommended that the third schedule of the Act, be amended to read, this third schedule of the Act shall be applicable to the single buyer. We do not consider that this recommendation is critical. We do note that in section 20, or section 4, which creates the right of first refusal, that express reference is made there to the third schedule, which contains the terms on which the right of first refusal may be exercised. And therefore, that amendment is not necessary.
Ms. Campbell, you are saying with regard to the right of first refusal in the schedule before, that the ministry is proposing to not, what was the ministry's proposal on that? Because it does seem to have some connection to the PSOJ's recommendation here, doesn't it? Or am I reading incorrectly? Not that JIE one, the one before.
Oh,
you're saying that.
They were asking for the right of first refusal, if it's not removed, to extend to all generators.
Oh, okay, got you. And the PSOJ is proposing in their recommendation, which you are not accepting,
right,
that it must be applicable to the single buyer. And you're saying that that is not necessary to be stated to the single buyer.
Right, because the enabling provision at section 20 already expresses that.
Okay, thank you.
The single buyer, and that the third schedule contains the terms on which it may be exercised. WRB Energy, in relation to the third schedule, recommends or expresses their concern that as it relates to the third schedule, part 1B, the generation avoided cost must be updated and published by the ministry every 2 years. As written, the added right of first refusal concept and implementing language is at best anti-competitive, and in practice has and will cast a pall on the effective operations of the competitive market. We therefore recommend that the right of first refusal provisions be removed and that all future generation capacity, whether it is for thermal, renewable energy storage or other generation, be procured by the GPE through open public competitive bidding programs. We acknowledge the concern, and as indicated above, the policy of the ministry is to move towards competitiveness, and we have also proposed that the provision concerning the right of first refusal comes to an end at the end of the license. They continue. Failing the removal of the right of first refusal, we recommend that the provisions be revised to require energy pricing offered to replacement projects be no higher than those that would be paid to. That sounds. Avoid this before. Those that would be paid to projects of the like type procured through competitive bidding processes. In the case where a competitive process is not feasible or practical, the pricing must be set via a proxy for a competitive process conducted by an independent third party with knowledge of the status of the global market and future trends. Okay, so our response is that the law addresses the concern in that the pricing for replacement of generation capacity is determined by the avoided cost developed as part of the integrated resource plan. And this plan has a 2-year cycle, running cycle. The cost applies to replacement by competitive means and through the right of first refusal. At paragraph D, it is expressly required that the replacement cost not to exceed the generation avoided cost published in the IRP. Paragraph 2 goes further to state that if the replacement cost exceeds the generation avoided cost, then the replacement will be procured competitively. So if it is that the terms of exercising the right of first refusal are not met as stipulated in the third schedule, then the replacement of the end-of-life generation plant would have to be done competitively. And that's an express requirement. So it provides another avenue if the right of first refusal is not exercised as in the manner the law requires. The Jamaica Public Service, in its comment on the third schedule, part 1A, they are proposing that there is an inclusion of a timeline for the review and update of the planned schedule by the minister under the Act. And we agree and will require that the retirement schedule be updated every 2 years in line with the development of the IRP, the Integrated Resource Plan. In relation to B, paragraph 1B, the JPS in its comments requires that there is a specific time by which a notification letter is to be sent by the minister to allow for the orderly planning and development activities. They recommend a minimum of 6 years prior to the scheduled retirement date of the asset. The ministry is recommending that the notification letter is issued 4 years prior to the scheduled retirement date. To support transparency and predictability, the ministry, as part of the IRP process, should publish a methodology for determination of the avoided cost of generation that will form the basis for the biannual update. The methodology is published in the Integrated Resource Plan. The Integrated Resource Plan is also open to public consultation. It is updated every 2 years and is available on the ministry's website. So that document publishes the methodology used in determining the avoided cost. Paragraph 1D. The inclusion of a provision for the GPE to table a report to Parliament within a specified period, setting out the reasons for capacity procurement decision. These comments regarding the GPE, the inclusion of a provision for the GPE to be established as a legal entity, clearly setting out its powers and functions with respect to the procurement of additional generation capacity to the grid, having a complete framework outlining the terms of reference, tenure, technical competence, qualification, and composition should be included to allow for a transparent procurement process controlled by persons having the requisite technical competence. An obligation should be imposed on the GPE members and appointees to disclose conflicts of interest, including those arising by virtue of close family and business relationships, in addition to a precise mechanism to address real and potential conflicts of interest by members and appointees, including grounds for disqualification and removal. To provide certainty in relation to the procurement process, we are of the view that the rules and protocols to be developed should now be developed and included as a schedule to the Act, and must also benefit from policy assessment carried out to enable the current review exercise. The rules and the protocols, like the Act, should also benefit from periodic review to ensure that they are relevant and current. These were addressed in our review of section 20. The ministry, prior to the establishment of the Special Joint Selects Committee, had already obtained cabinet approval, and the bill was in the drafting stage for the legal framework to establish the GPE as an independent entity. There are provisions related to tenure, who the members should be, how they are to be selected. There are requirements for GPE to adhere to rules of transparency, accountability in relation to requirements of public bodies. So that draft, there is information in relation to the constitution of the composition of the GPE, and it names the technical capacity and the tenure of the members, provisions concerning meeting procedures, conflict of interest. So those requirements are satisfied.
You know, Ms. Campbell, and I don't want to not adhere to the rules, but as I was listening to the recommendations being made, I found it a little odd because these are quite standard and would have already been incorporated. So I was trying to understand the basis on which those recommendations were being made. It's conflict of interest, tenure, the composition, and all of that. It was quite, I was kind of curious where those recommendations were coming from, you know,
Okay.
but thanks for the confirmation that these already exist.
Yes. The third schedule section 20, section 2, right of first refusal. The OUR in relation to paragraph 2 says that in the event that the owner of the generation set does not exercise the right of first refusal or in exercising its right exceeds the avoided cost, then that replacement capacity will be procured competitively from local and international markets. The OUR says that the wording is not sufficiently definitive, the existing wording. They propose that that paragraph 2 be reworded to say the replacement capacity will be procured by means of competitive bidding for generation capacity by potential independent producers from local and international markets. So what they're adding is independent producers. We don't object to that. DMR Energy is proposing that the right of first refusal be deleted. It's similar to one that I've read above. And so the position is the same in terms of the fact that we are of the view that the right of first refusal should remain and that there be a provision for it to terminate at the end of the JPS license, which expires in 2027. They have also said that, so it is the same, I think this might be a repeat, or they have said the same thing, our position is still the same. There are terms on which the right of first refusal must be exercised, and if it is not exercised according to those terms, then the replacement of the generation set would go to competitive bidding. WRB Energy says it is the same. It's the same comment or concern. This might be repeated. We've dealt with that before. So we may move on to the JEP. Jamaica Energy Partners said there should be no right of first refusal in the sector as it does not promote competitiveness and investor confidence. However, if the government decides it is necessary, we posit the following. 1, determination of the avoided cost should be clear, transparent, and unambiguous. It should be done by the OUR and not the ministry. Or if done by the ministry, should be independently verified. The right of first refusal should be removed in its entirety from the single buyer, or if it should be applicable, I suppose it should be applicable to all generators if it's not removed from the single buyer. And we've also, let me begin with that. We've expressed the view above that we have a limit on the right of first refusal that we're proposing, and that we do not agree that it should be applied to all generators because the policy of the ministry is to move towards competitiveness in the provision of electricity. In relation to the point of the the method, the determination of the avoided cost to be transparent. We've mentioned that the avoided cost methodology is published in the IRP, and the IRP is open to public consultation. And for just in summary, the long run marginal cost method is used in determining the IRP, and OUR made a presentation on this to the Joint Select Committee in a prior meeting. The long range method considers the fixed operational and management cost, the capital cost, the variable operational and management cost, the energy not served cost, the fuel savings and fuel cost. And this is in response to changes in customer demand over a 20-year outlook, usually in consideration of the life of the generation set. The avoided cost, so the summary is about how it is determined. The JEP have also proposed that the OUR should develop the avoided cost, and if it's not done by the OUR, it's independently verified. We wish to indicate that the OUR is a stakeholder in the IRP consultation process, through which the generation avoided cost is developed, and they are fully entitled to bring their opinion to bear on any cost arrived at. And the OUR is also guided by the avoided cost in its determination of the rates to be applied in the generation of electricity. So that is the extent of the response to JEP. Let's ask what you repeat. In relation to the fourth schedule, the PSOJ has proposed that the fourth schedule, part 3, be amended to provide that in the case of the absence of the chairman or other member, or the inability of the chairman or other member to exercise his or her duty. So paragraph 3 says that the minister may appoint any person to act in the place of a chairman or other member of the tribunal in the case of the absence or inability to act of the chairman or other member. So it's just to clarify, because there's one word that doesn't read properly, and the proposal of the PSOJ is accepted. For consistency, we recommend that the name of the tribunal appearing at the top of the fourth schedule be restated to name Electricity Appeal Tribunal and not Appeal Electricity Tribunal, for consistency with section 51. We propose that paragraph 12 rather be amended to separate the powers, two powers that are there, and to enter them separately. The current provisions of the tribunal shall regulate its own proceedings and may award costs against the losing party in any proceedings. We are proposing that the amendment be done to separate those two powers. One should read that the tribunal may award cost against any losing party in any proceedings, and the other should say, subject to the provisions of this act, the tribunal may regulate its own proceedings. So there's no change in substance. This is the end of this portion of the matrix.
We're almost at 12:30 now. So maybe it's a good time to break.
Yes, Minister.
Agreed, Minister.
Yeah. So the proposed dates for the next meeting is Thursday, October 12th at 2 p.m. and Thursday, the 26th of October at 2 p.m. Based on the fact that Parliament has now resumed after summer break. So these are the two proposed dates. Let me repeat them. Thursday, October 12th at 2 p.m. Thursday, October 26th at 2 p.m.
Okay.
How are those for you, Member Allen, Member Campbell?
Good for me, Minister. Good for me.
The 12th is good for me, Minister, and the other one is the 26th.
Mm-hmm.
These are both open, Minister. Thank you.
All right, let's go for them. So we block those in,
Okay.
Ms. Beckford, and then we can take the minutes of the last meeting and this meeting at the next sitting. So thank you very much, Ms. Campbell. Thank you to the ministry team and of course all the supporting staff, Ms. Beckford, and of course the OUR, CPC, and AGC. And we will meet again and hopefully continue to try and conclude this as quickly as possible. So next meeting, this meeting is adjourned and the next sitting is Thursday, October 12th, 2023 at 2 p.m.
Okay.
Thanks
Thank
for
you,
your
Minister.
input.
Thank
Thanks,
you,
Member
Minister.
Campbell, for
Absolutely.
filling in for me, and Member Allen for your participation.
Thank you,
Thank you.
Minister.
You're
Have a
welcome.
great day.
Bye.